Namaskar, everyone. Welcome to our channel of Sue You Soon. And as is our mandate, we always endeavor to bring legal luminaries, not just from India, but from the world over to this channel, so that at least in this draconian phase of pandemic, we can introduce some positivity, we can infuse some good thoughts in the society. And in this humble endeavor, we have a very special guest today with us, Mr. Sudha Ramalingam ji, who is a very senior lawyer practicing in the Madras High Court for the last 4 decades. And today, it will be my endeavor to probe her into her life journey, her struggles, her successes, her achievements, which have been far too many. And I think in this journey of over 60 minutes, we'll try to put some pointed questions to her about court, about litigation, about intricacies of law, and other things. Ma'am, very warm welcome to our program. See you soon.
Namaskar to you too.
And before we start our formal Q&A series, as a matter of custom, we always ask our guest who we have invited to please enlighten our viewers about your initial life journey, your early education before you decided to be a lawyer, and what was that point in your life and career which propelled you to pursue law as a undergrad as a graduate course, and then eventually you proceeded to become a lawyer. So first your early education, and then we'll come to your first the BA degree, and then the legal degree, and then we'll start with your professional journey.
So I was born and brought up in Chennai to intercaste parents, and I actually was fortunate enough to have had the best of education in one of the best schools in Chennai. So I had the opportunity to have had the English education. And I went to Queen Mary's College to do my BA Social Sciences, which was a composite course of sociology, psychology, and philosophy together as main subjects, unlike other subjects where they used to have a major and ancillary. And I went on to do my post-graduation in my Madras University of Social Sciences itself. Had a ruckus with my professors there because I was supporting some of my friends who had some issues with the university professor. And
Right.
so, though I had my university rank in some of the subjects in my MA degree, I, along with some of my friends, were detained in the postgraduate studies. So those days they would not take our TC and CC in the university departments when we joined there. So I did apply for my law degree, and they used to have an interview. When they asked me what I was doing for the 2 years, I had actually by then also filed a writ petition against the Madras University. And so I told them I was only learning my stitching, embroidery, and typewriting, so on and so forth, and marking time between education and marriage. And as it did not happen, I've come here for my interview for my law. But law was my passion even before that. My parents did not want me to do law because they thought law is only for male bastion and a place where you'll have to tell a lot of lies. So I did have this at the back of my mind that someday I will do law, I will become a lawyer, but it happened sooner. And I did apply, get my admission also because I had my state rank in my UG degree itself. And so there I started the journey of doing law, and I enrolled myself immediately after.
Wonderful narration, ma'am. I would just like to take you back to the 70s decades where you pursued law as your degree. How different were those times? And I ask this from a perspective of our young viewers because our young listeners are always very keen to know how life was in 70s when people pursued law, especially as you said that ladies were not promoted so much to pursue law as a career. You said your family had some reservation also, and what was the atmosphere like in the 70s, especially in terms of internships, writing articles, doing any other co-curricular activities? Were these available to you at that point in time when you were pursuing your three-year law course?
See, as far as law course is concerned, as far as my classes in law college were concerned, it was really taken up very, very fully. Classes were conducted only for 3 hours a day, between 9 to 1 or 2 to 5. And most often than not, the teachers would not be there. And if there were about more than 700 or 800 students, about seven sections, and nothing serious happened at all. I don't even, except for a very, very few teaching staff, not many were even interested in really teaching. And most of them were also part-time teachers, so they were all interested in their own practices. So, and we had a good library, but very few of us use the library as such because we had to be self-motivated those days. Otherwise, law generally the 3 year course was seen to be the last course for people who did not get jobs or who had their fathers or somebody else who were practicing and they wanted to continue with the practice. Otherwise, it was only a stopgap arrangement for many and more so for women. We were very few. And of course, by the time I went in my classes, we were about 30 of us in about, of course, 700 odd students, about 30, 35 of us were women in the class. But nobody was that serious about taking law course to pursue their practice as such.
Right. I mean, the times have really changed because I think when we see law students today, I
And
think
I also want to add
things.
one more
Yes.
thing. I just want to add one more thing. Yeah, you can cut and paste, no?
No, we can do it, ma'am. No problem.
Please, because it was also the days when emergency came in. So
Right.
we were all more interested in forming ourselves into group. I got involved with the People's Union for Civil Liberties, which was the call given by Jay Prakash Narayan. So we were all doing much more of underground work than attending classes. That is
Wow.
the reality.
So I would like to know about that phase because emergency is such a landmark phase in the historical period of the country. What prompted you to be part of emergency? I know that JP movement, as we popularly call it, was very popular back in those days. As a law student, as a future lawyer to be back in those days, especially emergency was counted, and I know that. Obviously, I was not born in the 70s, but the story that we keep hearing is that lot many people are also being languishing in jails, and the moment you would speak against the system, you'd be put behind the bars. So, how did that frame your personality, as a young law student?
See, I told you I went into law school itself because I had rebelled against the university. And it was inherent in me to actually not accept the routine. And in fact, my application to law college was not even known to my parents. It was my choice and not their choice. So this is how I had to push with the help of some other friends after I got my admission to make my parents accept to send me to the law college itself. They were the days when we got interested in the fundamental democratic principles as such.
Right.
When our right to freedom of speech was curbed, when papers were published after censorship only, when quite a number of people whom we revered and were languishing in jails, we thought, people like me thought that it is our duty to start fighting and forming ourselves into groups. So it was quite natural for a youngster to be attracted towards such a movement because this was just called also the second independence movement during my days.
Right, right. And if I may just put a small question here, because a lot of universities and young law students are thinking that we are living similar in an era of emergency today. Uh, is that so? What is your opinion on that?
Absolutely. I think this is the second undeclared emergency days. And so I'd be so happy if only youngsters are going to gather up together and form the ensure that the alternative to these, the Congress and the BJP governments. I feel that my generation has failed. At least the next generation should come up with something which is selfless and only for the sake of the society and not for themselves.
I think that's an excellent answer, ma'am. Let me now take you to your starting journey as a young professional. If you can just shed some light as to how you started your career, which chambers did you join, what did you learn there, and then we'll come to your current curriculum.
See, as far as my journey was concerned, as I told you, my parents did not accept me doing law, and as such, when I did complete law, they weren't very interested in also sending me to practice. In those days, we cannot go away and set up a household elsewhere because nobody will give a place for rent also. And
Right.
I also had no money to start on my own. And
Right.
as soon as my uh, education was over, immediately thereafter they were very busy looking out for a group for me more than anything else. And I was the only child of the parents. So for them, my entire life thing was their moksha was in giving me a matrimonial life. That's all they thought of it as. So you may, I had to so join with my friend's brother, Mr. Patabiraman. His father was very well known to me, and who was the person who was also an advocate, Mr. Nagaraj Rao. He is the one who went and told my parents to send me to law college. And so I joined his chambers. But unfortunately, he was a little sick and could not come together. And I also got married within months of my enrollment. So, and I conceived immediately thereafter. So these things took me away from the regular, usual rigor of being in a good office as such, which I really miss even till this day. But all said and done, Mr. Pattabhiram was a very nice person. He continued to help me even today. If I turn to him, he does help me, of course. So I started off as a civil litigator as such, and would also jump up to also go to Sessions Court, because Sessions Court and Civil Court are all in the same premises in Madras. So I could go to the Sessions Court, to the District Court, to the High Court, everything in the same campus. So that was a very great advantage for me. And I had a lot of friends. My husband also happened to be a trial lawyer. So his friends and other friends would, seeing me to be an energetic person who could be expressive in my oratory, so they all will help me to get my briefs.
That's an excellent narration. In fact, I have a follow-up question now for you, because this is something that I kept getting asked from the young viewers who are both law students and young lawyers, and across different parts of the country. One question that is repeatedly asked of me is, how does one establish a litigation practice? You being such a seasoned litigator now, practicing for at least 40 years, what tips would you give to young lawyers? One, how to establish practice, how to generate clientele, and how to sustain clientele, because these are very generic questions which always young lawyers ask. So what would be your advice on that?
See, I don't think we can give any tailor-made answer which would fit everybody. What actually is needed is one, of course, perseverance. Two, of course, proper contacts, being at the right place at the right time. Also equipping yourself whenever any litigation comes in. And now we have the Legal Aid Services Authority. So I would ask every lawyer who is new to the profession to go and enroll themselves in the Legal Aid Services Authority, offer themselves for pro bono work, and start be equipping yourself for whatever is going to come. See, I had another opportunity, advantage also of also being a woman. I used to be very active also with the All India Democratic Women's Association. So what happened is lots of women came into me. So I was thrown off with a lot of matrimonial work. So I practically specialized in matrimonial law also, and eventually family courts came into being. So we were thrown out with no other choice of getting to become specializing in these fields, more because the clientele came from that particular section. If I had been a labor union activist, I would have been a labor lawyer. So I don't think we can premeditate and say I'm going to be this only, that only, unless we are inheriting an office.
True.
Which is specializing in something. Otherwise, we do jump into every field, except for income tax. I think I've done things here, there, everywhere, litigated almost on all sides. We go to different courts. One day I'll be about 24 to 25 kilometers away from Chennai and Pune. Another day I'll be in Chengalpattu, more than 50 kilometers away. Another day in Tirunelveli. There have been even instances where I've come to Supreme Court. Just drive down, park the car, and come to Delhi and get back also. So from the lower court, municipal court, to the Supreme Court, everywhere any lawyer can practice, provided you have the dedication to do it and equip yourself for it.
Right. So, ma'am, the other question that I have for you is, because you have practiced across different fora, from trial court to Supreme Court to High Court, obviously, and different tribunals also, as you rightly said, and a lot of traveling, including that. But what would be your advice to a young listeners? Because many a times it is seen that young lawyers straight away want to start from Supreme Court, or perhaps set up their practice in High Court and skip, very conveniently, if I may say so, the trial court practice. What would you like to tell them? Should they skip trial court practice, or is it at least mandatory in your formative years to dabble in the world of trial court law?
See, I have also had the fortune of being mentored by Mr. K.G. Kadabira. So he was the president of the People's Union, for national president of the People's Union for Civil Liberties, and he would always tell us, Article 21 must first be seen from the magistrate courts. So work down, up, and not up, down. So we should always understand the magistrate's powers are much more than even the Supreme Court judge's powers at times. So what we'll have to think about and learn, understand is no court is a lower court. To even call this a lower court and then the High Court or the Supreme Court itself, I think is given us a different way of looking at these forums. We have to learn the trial court work also if we want to effectively work in the High Courts and Supreme Courts.
Right. So I think that's a good message and takeaway for all the viewers here who will listen to our episode as and when it's uploaded. But having said that, ma'am, because you are such a stalwart in the area of human rights, and that is something which still today intrigues a lot many youngsters, newcomers, and even people from civil society. What would be your advice to our listeners? How should they pursue a career in human rights law? Because it's a vast field. I mean, it's easier said than done. When I say human rights, few things perhaps may a few images may come in our mind, but it's more than that. I think every time, at least, is I can speak for myself. Is even if I'm trying to secure a bail or if I'm trying to secure basic freedom for somebody, I think it's a matter of human rights. So, what, in your opinion, one is human rights, and if you can expand on that definition a little more and tell our viewers how in your legal journey you have faced and faced the challenges and how you succeeded in terms of dabbling in the world of human rights law and litigation.
See, I won't say that I really succeeded fully. There's so much to walk through here. So nobody could ever succeed immediately at this point of time. There's so much to do. See, as far as human rights is concerned, as you rightly said, it is not confined to only some physical abuse or anything like that. Even environmental rights, your right to food, your right to clean air, to right to clean water. Everything comes under the human rights purview only. So what we'll have to now understand is, as far as India is concerned, we do not have any backing for lawyers who can specialize only in human rights work. I have to actually run my office, wherein I cannot tell my juniors, you also be pro bono lawyer for everything. Just can't do it. Yeah. So we'll have to also know where the bread and butter is. True. So what I would generally say, as far as we in India are concerned, we'll have to definitely also take up work for our earning to run an office. After all, the client does not come if you are going to be under the tree only. He might come for once in a while, but not always. They also look upon you. They have to see you having a pretty decent office. And we also need a little, a little show in this business of profession. I would call it also a business of profession because we have got to make a little money. Without money, I cannot be running the ship. So if I've got to give rent, if I've got to pay the juniors, if I've got to have have a printer at a computer, or even if I need a Zoom call, what do? I need to earn. I can't be bringing it from my home and then doing this work. So every lawyer should understand before taking up other work, they should also learn to ethically practice and earn. You can definitely earn through ethical practice and also use your extra resources or a little more resources, set apart a little time at least for the sake of the society, for the sake of the human rights work, and for the sake of bringing in a better world, building a better world.
I think that's a very fair point that you've made. And when you spoke of bread and butter, that a lawyer has to focus on different areas of practice, just to sustain their office and the business. That because it's also business at the besides being a noble profession, because you have office to run, there are expenses that have to be taken care of, etc. So many times it's asked in terms of the bread and butter question. Let me put it straight away, because these young lawyers, fresh graduate, ask me a very basic question: is how does one make money in the profession? And that's $1 million question when it comes to litigation. So, what would be your tips to the young viewers on that?
See, even the Legal Aid Services Authority now does pay a little to the advocates. Yes. For it. So we can even, if you are going in for a jail visit through the legal aid, you earn a little. So how much is the question, and how are you going to, whether are you going to be satisfied with little, and what is little and what is more is also a relatively subjective question. Right. For me, an auto car may be enough. For another person, it could be something, may need a Toyota. Another person may say BMW itself is only minimal. So it all depends on how much you say is satisfying. So if only you can accept to a certain minimum in the beginning, I'm definite that is we can make a lot more as you climb up the ladder. If you're seen to be a sincere lawyer, if you're seen to be a dedicated person, if you're taken seriously, you will get your briefs. It's only a matter of time. We'll have to be a little patient too. This is not a place where you can succeed within a year or two. Of course, it takes at least 6 or 7 years, or even more than 10 years for really meeting both ends. In fact, Mr. Govind Swaminathan, Senior Counsel, used to say as a junior, you have the time but no money to spend. But as a senior, you have that money but no time to spend. This is how a life of a lawyer is.
True. I think that that's so true, and I just hope the young viewers here are not disheartened listening to this nugget of wisdom, because there's something even I have heard from my seniors, and now coming from literally from the horse's mouth, so as to say. Uh, this is something that there's no shortcut to hard work. You have to really work hard, and as you rightly said, ma'am, 10 years is at least the minimum that one has to put in the profession, at least to get the bearings right and understand the modalities of the profession, at least on what side of the court to stand initially when you're starting out, how to draft a brief, how to brief a senior, how to there's so many things, so many aspects to litigation which are involved. In fact, that brings me to my next question, which is the role of a mentor and a mentee, because this debate has really fired up of late, because I think when we speak of the 70s, 80s, even of the 90s, there was a good Guru Shishya Parampara. People had a keen sense of learning. But today, when we see with a lot of young graduates and young lawyers, people are very quick to branch off, start their own practice. Sometime maybe just 2 or 4 years of practice. Sometimes start a law firm, because now we have a lot of law firm culture also. And somewhere young students, even young interns, tend to complain that we are not getting enough mentorship in terms of guidance, or in terms of how to be in a law office, or in terms of how to draft, etc. There are quite a bit of problems there. So what is your take, ma'am, on mentor and mentee relationship, and how young lawyers can benefit from this culture, or how even the people who are the employers can ensure that within their office they have enough protocols or checks and balances to guide and instruct the young lawyers who are coming to the profession, so that we can eventually contribute equally for the benefit and the betterment of the profession.
See, as far as any lawyers who want to really establish themselves, there is no hard and fast rule which says you will have to be a junior for X number of years and only branch off to be your own independent self. As you rightly said, there is a lot of movement and I mean, youngsters have now started also joining together, starting their own law firms as such, unlike before. And also, there is also thing when I was a junior or when I started off, we had to go to depend on physical access to books and everything. But now everything is at the tip of your finger as such. So there's the internship that you are talking about. Fortunately, because I started off as a rebel, I had a person, Mr. Nagaraj Rao, office, which I used to go even as a first year's law student. But that was not there for many others. We did not have this culture of internship at all those days. So we had, and we did not even know what a wakalat was, where to sign a paper. In fact, people did not know that filing a paper or filing a papers have to be written and representation. So law school, law colleges did not teach us practical life, about practice as such. We only knew a few theoretical knowledge is what was imparted to us. So this Transfer of Property Act was taught to us, Specific Relief Act was taught to us. But where do you go and file this petition? Whether it is going to be in the district court, in the municipal court, or in the high court, what is the original side? These were things which we had to learn by ourselves, and which ourselves would mean only in our chambers. But now it is not so. You have so much material online. You have so many books here which will teach you. So and there are also a lot of associations, bar associations, advocates association are conducting a lot of classes now. And now during the pandemic, we also have a lot of online classes. And your channel itself seems to be one such, which gives a lot of inputs about how we can equip ourselves. So if there is a will, there is a way. That the physical interactions are definitely advantageous, but even otherwise, we can bring ourselves.
I think that's a very, very fair point. In fact, the next question, it stems out of the explanation that you just given is, I think ours is a very, very peculiar country where we still offer both 3 years and 5 year of law degree. We have not abolished the 3 year law culture in terms of the law school coming up in '88 when Professor Madhav Menon started the National Law School in Bangalore. So I would like to know your opinion on this. Do we still need to have both the courses running parallelly, or has the right time come when we should at least structure just one law course, maybe perhaps for 3 years or 4 years, and maybe a 1 year of compulsory internship, so as to say, because today so much of learning is available on online platforms. There are things which people can Google. There are online research mechanisms. Courts are slowly but steadily adopting the virtual court mechanism also. But do you think we have to have these two parallel courses, 3 years and 5 years, to create a lot of confusion, or just perhaps put a middle path somewhere where we can have a 3 or 4 year law degree and be done away with that? What will be your take on that?
I have the advantage of having undergone the 3 year law course, and also the advantage of seeing at close quarters the 5 year law course with my daughter going to national law school. So what I saw is my education, as I told you even in the beginning, was really nothing to do with academics as such. We had to struggle and learn ourselves. That's what it was. Even going to the school, law college was only because we had to compulsorily have certain percentage of attendance. Otherwise, we did not think of it as a place where we went for learning as such, and learning was actually from outside the college more than from inside. But whereas all the national law schools now, especially when I saw this at close quarters from national law school, the trimester really helps. Within the before about 1 month of the first trimester, the students are talking about even comparative compare with international judgments. So this sort of education that is now given to them with a focus on research methodology, bringing out small, what to say, they come out with research papers as such, and there is a viva followed with each of their research paper. So if there is going to be four subjects taught in the first trimester, there would be at least four research paper and for viva that they have faced, which is wonderful. So I feel this 5 year law course is very, very good and important. But at the same time, for people who think about getting into law seriously after their graduation, there is also a sense of maturity, and I think they also play an important part. It's not to belittle them. So I think both will have to be parallelly run. There's nothing wrong. I, for one, even feel there should be no age bar for getting into any law college or any law school as such, and for practice itself. Education is something which is a continuing learning process. So I don't think, I don't find any reason why there should be a ceiling. I know people who used to be working elsewhere and were employed full time and did evening law college, and then became even high court judges and were even elevated to Supreme Court, who did very well.
That is very true, ma'am. But I have another question, which perhaps you can give me your opinion on. Because there are both 3 years and 5 year law courses in our country, and the whole mandate of opening a national law school, based on whose model a lot of private law schools have now also come up with 5 year law courses. And I think 2-3 years ago, the Bar Council of India has in fact said that a lot of mushrooming was happening in terms of new law school cropping up in every nook and cranny of the country. So they have just given it a pause. They said we'll not give you license to practice, because what has happened is, when I interact with a lot many young law students, I see that in many of these private institutions, there are batches running up to 700 or 1,000 of students giving really expensive fees to these education institutions. And the problem is then everybody is looking for a job. So sometimes I feel that perhaps the whole the mandate of what a lawyer ought to be and what these law students are aiming to be are two very different things, because it is becoming at par with what we already faced in India in terms of BTech education and then MBA, that we had these colleges commonplace across the country, And I think at least for the past 2 to 4 years, I see a lot many young interns, final year law students are trying to find for a suitable job. But we know it that not everybody can crack a top chamber, not everybody can crack a top firm, and there are very limited number of law offices in the country. So how or what type of message needs to go out in terms of telling these law schools, be it private, be it national, be it 3 year, be it 5 year, that look, you cannot be toying with the future of any individual. I think in some way it's also a human right issue, if I can say so, because to say to a parent that look, at the end of 5 year or 3 year we are going to give you a very nice job or a pay package, or some people have been placed, but in actuality the reality is very different. So how can we deal with this problem in terms of our younger generation?
See, as far as education itself, education is not to be seen only in terms of placement and earning. Mainly, this academic degree is only a stepping stone, which would empower you and give you a license to practice.
Right.
Otherwise, there are lots of people who have done law, but who do not practice at all. It's not as if all law graduates should necessarily practice. They could take up any number of jobs, and quite a number of other organizations are also being promoted by people who have done law. And we, I somewhere feel that there is a problem when, as you rightly said, 700, 800 people being enrolled. You did not put it, but they would never even go to the college even one day. They would have got their attendance somehow and written their examination. There are lots of cases going on in the Madras High Court itself about how people have got fake degrees even when they have been full-time employees elsewhere. They are supposed to have attended law colleges in another state when they are employed in one state, and they get their degrees. In order to weed out such of those elements, you can't do away with everything. This is like, say, throwing out the baby with the bathwater. I think we'll have to ensure that the law colleges also inculcate an amount of ethics into people,
True.
and inculcate professional ideas into the people. But to say that we need not have the 3 year course or only have the 5 year course, I don't think that's right. What we need is a balanced, holistic approach. We need these people and them also. And if only you take away this age limit, maybe even if it is 5 years after your graduation, if the person is interested, they can do it.
I think, ma'am, the important point that you just rightly pointed out is how to embrace ethics, both in terms of academy and how we equip our future generation in terms of both moral and legal ethics. And I think that's a good takeaway from this answer. The next question, ma'am, I have for you is that you have been instrumental in prison reforms, especially in terms of women prisoners in Tamil Nadu. If you can just tell us about that journey that you had to undertake, and what are the work that you had to do in terms of uplifting, the under trial prisoners, women prisoners in the prisons there.
See, as a human rights activist, I've always been interested, of course, in prison and reforms as such, criminal reform. And when Dr. Vasthi Devi was the Tamil Nadu State Women's Commission chairperson, I happened to be the inducted as the law assistant there, and part-time, of course. And what happened was, it was also pro bono only. And what happened is, we used to go to every women prison in Tamil Nadu, and we of women prisoners there, and ensure that number of mm, suggestions were given, recommendations were given to see that there were humane conditions in these prisons. We saw that most of the prisoners were actually detained under the Preventive Detention Act, the Gundas Act, for illicit brewing and illicit sale of liquor. And we also found that these women were actually the wives or sisters or mother or say daughter of, in fact, their male counterpart in their families. And what happened, the excise wing and prohibition wing had certain quotas set upon them to be be shown as number of persons who are detained for prohibition offences under the Gundas Act. So they would not entertain men. They would just send away these women. And so when at one point of time when we went to the Vellore prison, we saw that more than 45% of women there were booked under the Gundas Act for prohibition offences only for preventive detention. So we, of course, spoke with the government and ensured that, in fact, Mr. Natarajan IPS, the then Commissioner of Police of the city, Madras city, Chennai city, did away with booking women under the Gundas Act for prohibition offences. So this was one thing, and of course providing sanitary napkins to these women prisoners, giving them better food, bringing in also these are suggestions which are given. And later on, the Madras High Court appointed me, Mr. A.P. Shah and Chandru Jain. They appointed me as commissioner to go into all the women prisons in Tamil Nadu. And I did go to every prison and every woman prison in Tamil Nadu, left, right, and center, without giving any prior notices. So could actually see and interact with these prisoners throughout the state. So we gave a set of recommendations. Everything was followed in that spirit, and it was followed up also. So some of the recommendations were giving them, as I said, sanitary napkins, and for on entry, every prisoner should be given one two sets of dresses, and then a pillow, a blanket, their all the minimal needs, a little coconut oil, soap, all these things. We said you give a entry kit itself on admission. And then we also ensure that rations be brought not from the ration shops, but from proper supermarkets, and quality provisions be given. And then we saw that there should be at least one four-wheeler set apart as an ambulance in lieu of at least an ambulance. And then there should be tertiary hospitals, which is nearer the prison and not far away from the prison. That's how it was in mostly in a few cases. There were so many other reforms that we spoke about, and I was fortunate enough to see that everything was accepted, and there was a general follow-up with also the Legal Aid Services Authority being asked to step in. And when they gave their follow-up saying that they have actually done their work, was asked to go back again and see whether what was given by the state was real or not. And there were times, a few instances which was not really honest revelations, which we did seal it up later by the follow-up visits.
That's a Herculean task, I think, that you undertook. If I may just ask, how many prisons in terms of numbers did you visit back in those days?
So there were about, I think, 20, 21 prisons as for in Tamil Nadu. That is, there were 3 central prisons, and all the others were sub-jails. And it's interesting. The children there, I recommended that there should be recreation facilities given. The next time I go, the superintendent will tell me, "Madam, there's a carom board. We have got the chess. We have got that, this, everything." And where is it? It will be only the superintendent's office. It's never given away. They'd say that the cradle purchased, madam, you told for the children here we need a cradle is purchased. But the cradle will not be in where the child is kept. It will be in the office room. So there's so many things here. There'll be a refrigerator there, but nothing will be used. It will be like as if it's in a showroom. So the instances where in one of the jails I saw that monkeys would come. What was the problem? Monkey menace. So in Krishnagiri sub-jail, we had to ensure that there was a net put up throughout the open areas. So we could go out and keep their even the plates outside. The monkeys would take them away. So peculiar things. We also got provision for RO water to be given. I mean, to set up RO plants for every to ensure that there's clean drinking water. In fact, in all the jails, you should there never used to be a partition and a door for the bathrooms and toilets. It should be surprising in all the dormitories. There would be only about 2 feet high small wall partition, and you can see any person sitting there and spotting there. So we ensured that 6 feet high wall and a board we put up, fans we put up. So many things, the hygienic conditions we improved. And actually look at it, there's so many things that we even giving them nutritious food. Milk would be served for the children there, and the milk would be given at one stage in the morning. And what happens? Cold milk by evening it will be spoiled. So we ensure that milk be given twice a day, and also give patients for warm milk. Many things were done, and it's now followed in transparent, they say, also in the main prison for as far as other facilities are concerned.
It's such a
And even,
wonderful philanthropic work.
yeah,
But
because even
please.
scan has to be installed. You won't believe earlier on when a person goes into the prison, they'd be stripped naked, and they won't believe there'll be a mirror kept underneath, and they may be asked to stand with their legs spread out. It's really inhumane. So such things were also done away with.
What a wonderful experience, ma'am. I mean, so many takeaways from me just from this prison reform experience that you have outlined. But it's also shocking that authorities and the courts, which are also a crucial part of the system, who know that under their nose these things are being done, do not proactively take these things, and then we as human rights lawyers or activists, so as to say, have to step in, have to tell these things either to the court or to the government that look, these things are happening, human rights are getting violated, and as you rightly pointed out, in terms of small children or babies who are and lactating mothers who may require at least two times of milk a day, is such basic things like that are also being deprived to the prisoners. And sometimes, at least in my practice, I've seen, and I'm sure, ma'am, you may agree with me to some extent, that the magistrate or the session judge can give them bail, but sometimes they just are not interested in or willing to listen the matter then and there, and as a matter of default judicial regime, if I may say so, just send them to prison, and then it keeps getting extended for 14 days and 14 days and so on and so forth till the time the charge sheet is filed, and so on and so forth. And that is one complaint, I think, which we have uniformly seen across the decades, that prison reforms do need an overhauling in our country, and that so far as the criminal jurisprudence is concerned, things need to be a little more fast-tracked than they are today. What is your take on that?
You're absolutely right. As far as any person who's being remanded is concerned, the duty of the magistrate is to look at them first, see whether there is any visible marks on them, and ask them when and where they were arrested and how they were being brought up there. But nothing is routine orders of dismissal of bails or routine remand orders. It's every day, day in and day out. That's why one of our recommendations also that on entry, on admission, every prisoner should actually be not merely scanned, but the doctor will have to also give a medical certificate, and also the superintendent should ask when and where they are were remanded and whether they have any bodily injury on them, and if there is any, to also record that. All these things have also been given. See, as far as remand is concerned, if only the magistrates are honest and they do their work properly, police will not be emboldened to torture anyone. It's only because doctors are actually turning their blind eye to people who are being brought before them before remand, and the magistrates are also turning a blind eye and routinely remanding people, that torture is happening all over the country in every police station or by the police.
Right. I think that's a very, very important point, I think, which we all together have to ponder on, be it judges, be it lawyers, be it the system, because I think this is such a basic thing. And the other takeaway that I have from this, ma'am, is, as you rightly pointed out, that magistrates routinely, without even looking into a matter, just remand people into custody, which I think is a very sorry scene, because this emboldens the police sometimes, even in a false matter, to prejudice a person's valid legal right that they may have. The other thing is, sometimes I have seen, and not just in Tamil Nadu, in other states also where I have had the chance to argue, sometimes even the session judges or the magistrate judges, so as to say, don't even look at a file and routinely dismiss a bail application, which means the journey of a person. Delhi is different, Chennai is different because these are metropolitan cities. But if you're talking of larger state, if I'm let's say talking of Tamil Nadu, if a person who is in a village who has to come from a mufassal or a tehsil and then go to High Court to argue his bail petition, the journey of that person, not only financially but emotionally, is so huge and is spirit breaking sometimes, because one, they have to find the right lawyer, then it's a matter of luck against which judge that matter is going to be decided. Also, the rate of pendency in the country is quite dismal, because then becomes the problem. Then how do we train or how do we educate the district judiciary that please do not dismiss these things routinely, because sometimes there is a fear of the administration or the administrative process or a promotion
Or their
getting
promotions.
result. So that becomes a
See,
problem. How do we do away with that?
See, I did an interesting case where a magistrate had routinely not merely remanded the accused, but also the victim. This was a case where it was a breach of promise to marry, and she, instead of just breach of promise to marry, they also included rape and other offenses. So later on, of course, the fellow was actually acquitted because of the improper investigation. That's another matter altogether. But this girl was also actually remanded to judicial custody. She was found in the Hosur women prison sub jail by the legal aid advocate who went there. And then he files a bail application and gets her out. Then, of course, through the Women's Commission, which was to which this problem was brought, notice of this problem was brought to. I also filed a writ petition and got her a compensation. We also ensured that a disciplinary action is taken against the remanding magistrate, but not always does this happen. So routine remanding is a fact, and the doctors also are to be implicated in these matters as such, wherever there is physical injury caused and which has been not noted while they were being produced, because before producing them before the magistrate, they have to be produced before the doctor also, etc.
Right.
So
Right.
what happens at that stage? And also the jail authorities, when these people are brought to the jail on admission, they also have got to note all these things. All custodial death cases, especially the recent one, the Benix and his father. So what happened there in Tirunelveli? We see every stage there was a failure, gross failure after failure. The police committed custodial violence. The doctor did not bother. The magistrate did not bother. The jail authorities also did not send them to the hospital the same day. They also failed in their duty to give them medical help immediately.
I think, ma'am, that's a very valid point that you have raised. That compensation is something that is normally not envisaged in a criminal procedure, and for that you have to again have a different battle. And people are so broken by the time they get a decision or a judgment in a case, be it an acquittal, be it a conviction, that they don't have the the will to fight the system, because the system is too archaic, so as to say. But that also brings me to my next question, because you also have a great practice on the matrimonial side, and sometime and I'm sure you must be representing both the husband and the wife side, because in a matrimonial dispute that's the standard, but I often keep getting these queries from the husband side, and a few webinars that I've done in the past year or so, people keep asking me this question: what about men's right, that they don't have enough laws to protect them in the country? What is your take on that? Has the time come to have gender neutral laws in the country?
We still, I don't think, have time come to that stage where we need gender neutral laws, but definitely remedies are being given to men also. It is not so as far as child custody are concerned. We see co-parenting becoming the rule and not just simply one parent taking advantage of the having custody of the child. Having said that, I think what is more necessary is faster remedies. Cases hang on for years and years and decades also times. So what we really need is the laws, I think, as far as the matrimonial laws of Hindu Marriage Act or the Indian Divorce Act are all concerned, or the Special Marriage Act. They are definitely not pro-woman or a pro-man. Only custodial battle could be seen to be pro-woman or pro-man. Of course, Dowry Prohibition Act and the Domestic Violence Act, of course, is definitely pro-woman. But we have not reached a stage when we can deprive women of these advantages and also put them to greater disadvantage through these laws. We are still in a society where we, the larger number of women are victims, unlike the few urban educated or that could be an abuse. I don't say no. Everything can be abused. A knife can be abused. Fire can be abused. Everything that's very essential can also be abused. So can you do away with fire, your knife, or anything else? So I don't think only women-centric laws are abused.
Right. So time is not right to have gender neutral laws. I think the laws which are there in place are intact, and the judiciary is doing what they ought to be doing, because they, as you rightly said, that yes, judges are taking enough precaution, in fact, to ensure that no lopsided justice or judgment is given, and that also I see in my day-to-day practice that judges are also quite concerned that they listen to both the parties. Both the parties are given their due process and their due in the court of law. In fact, that brings me to my next question, that we are living in an era of pandemic, and we have gone from physical court to virtual courts. How have you seen the transition in your practice, and where do you see the judiciary going forward in the next 2 to 4 years? Are they going to embrace virtual court hearings as a matter of a greater good, which also to some extent ensures the last mile justice delivery in our country? Or do you think the courts are again going back to go to the physical courtroom, which will ensure again running from pillar to post? If a lawyer has practice in multiple forums, they have to find a parking, they have to seek adjournments, they have to seek passovers. What is your take on that?
See, as far as the pandemic is concerned, when digital courts have opened up, we have to see it from different spectrum, I think. You cannot say that it is good or bad as such. It is not white and black. There are lots of gray shades in between. I have benefited by the use of this infrastructure because I have the infrastructure, but not many can afford this. How many lawyers have facilities of an office room and good internet connection and also the technical know-how? We have not been trained for that as such. So we have got to see that there is, we have both hybrid courts as such. For those who want to use the this infrastructure facility of the digital courts, we can have them. For those who, and there are also instances where personal attendance cannot be really done away with. There are instances where you will have to definitely go to the court and physically tell certain things. There are instances where a child may have to speak. The child cannot be asked to speak on the, and if the court has to decide on the preference of the child, they can only question the child in the chamber, in private, not in on a video camera. So, and also telling that the advocate who is addressing the court over the video should be sitting in an office and addressing and not on the tree. I think it is very lopsided. I find that there is, unless all bar associations, advocates associations, and other organizations also come forward with shared office spaces where you will have more facilities for video conferencing, and we cannot really do away with personal hearings. I can give you one small example of a habeas corpus petition in which I filed. The detainee was a woman journalist confined by her parents because she had they said thought that she's going to run away elope with her boyfriend, and the police was asked to go and bring her before the superintendent of police of that district and produce her through the video conference. The police told the court was dare enough to tell the court that the house was locked, but you know what? The house was not locked. It was another house that they showed. So we immediately said it was not locked. So the court immediately asked us to show the house. We could show it through the video conference and then get the parents also to talk. The police was seen standing before the particular house, and the inspector was asked to go in, and the girl was also questioned. She was freed that very day. So I had an advantage of freeing a person who was confined, detained, But otherwise, I could never have shown the court that they were talking about another house and not this particular house in which the detainee was actually living. So it is an advantage, but it has been also a great disadvantage for many lawyers to not merely the litigants, because they do not have that infrastructure. And the litigants also cannot afford to engage only those advocates who have all this infrastructure, who may be much more costlier. So we'll have to find out some means of having a method through which we can give access to this technology. Until that access to this technology is available to everyone, we have to ensure that there is also definitely personal hearings.
I think that's a very good suggestion that you've given, that perhaps as of now, hybrid is something that the court should try to embrace, because there is obviously a discrepancy between the different type of lawyers that we have in the country. And it will only be fair to everybody to have that access to court. And the wonderful narrative that you just gave from your own personal example of on how you rescued this lady. In fact, something similar I just saw, I think last month or last month on YouTube, where I think one of the American courts had a similar situation where I think a public prosecutor was taking the deposition in camera and using Zoom as a mode of judicial proceedings. And the lady was seemed to be a little terrified. And then the prosecutor quietly just told the police persons to go and check out the premises. And the perpetrator of the crime, the accused of the crime, was sitting in the same house trying to threaten her at the time of deposition, and then he was quickly arrested. So something similar to I think your narrative also, that we need lawyers like you who are really, you really know the court craft, who are nimble on their feet, and who have had the benefit and such rich experience to assess the court. Having said that, madam, I've taken so much of your valuable time today. But before we conclude the session, we always request our guests to have closing comments for our young viewers. And when I say young, I just don't mean the youth. I also mean people who are young at heart and young in mind.
Yeah, I think every lawyer should understand, more so youngsters, is that it is okay to make mistakes. If you think that you are not, you are wrong, it's all right. You may be wrong, or nothing is static. There's a lot of change going on. And if you think you want to really succeed in this profession, kindly equip yourself, read. Another thing is, go to courts. Even if you do not have any hearing, go there, sit there, understand how the judge is questioning others, how the court is being conducted. If you don't have the opportunity to be in a good office, go to the court halls, or now even through the video conferencing, actually log into the courts where interesting cases are being heard. And ensure that you learn this code craft. There is no spoon feeding possible at all. As far as this profession is concerned, every day we actually see newer and newer cases. I actually, even yesterday, was getting somebody's problems, and I found that I never heard such issues at all. This more than 4 decades of my practice. So what every advocate should understand is that he or she is definitely unique. Things that are coming to him or her is also unique. Of course, there are precedents which have to be looked upon. We have to read up. Just because it's unique, you can't be unprepared with things. You be prepared, but also think out of your hat and understand that success is not merely money. Money will come to you if you really work hard. Thank you.
Thank you so much, ma'am, for your valuable time. And I think I've had so many takeaways and such a huge learning experience for me having this candid conversation with you. And I'm sure my our young listeners and viewers will also benefit as and when we upload this episode. In fact, just to summarize and what you rightly said, please don't run after money. Money will come, but work hard, read as much as you can, try to have the best takeaways from the legal industry. If you want to pursue a career in human rights, prison reforms, matrimony, I think this episode is a must for you. Please watch it and learn from ma'am's rich experience that she has shared with us. And I always appeal to our viewers that if you think that this endeavor that we have started in this pandemic, and if you're talking useful things that you think you are getting benefited from and other people can also get benefited from, the easiest way to promote this goodwill is to like, share and subscribe our channel. Until next time, see you soon.